You're looking live right now outside of the Supreme Court. It's where both those for and against abortion rights have been gathering all day. That ruling came after a case involving a Mississippi law that banned abortions after 15 weeks of pregnancy. Now, unless Congress passes new legislation, abortion rights will be determined on the state level.
Justice Samuel Alito delivered the majority opinion, writing that the Constitution does not confer a right to abortion. Justice Clarence Thomas joined the majority, but turned his attention to the court's past rulings on access to contraceptives and same-sex marriage as well. Thomas says in future cases, the court should reconsider all of the court's substantive due process precedents.
Yeah, for 50 years, women across the nation have had a constitutional right to abortion up until fetal viability, which is about 24 weeks when a fetus can survive outside of the womb. Now, the Supreme Court's decision impacts millions of women across our country, but today's opinion could start a domino effect for millions more. So the question we're asking tonight is, what happens next? When does it end?
Yeah, joining us right now, American University constitutional law professor Leah Epperson right now joining us to talk more about that. Good to see you, Ms. Epperson.
Thank you for having me.
Let's get right to the first question. What's your assessment of the court's decision today?
Well, it's certainly a stunning and sobering decision. It is a rollback of our constitutional rights. It is something that is really something that we have not seen in many, many years. So this is a right that has been deemed to be fundamental, protected by the Constitution, by the notion of liberty in the 14th Amendment Due Process Clause for 50 years. And the Supreme Court, which is a body that is known for its power coming from the legitimacy within its decisions, its institutional legitimacy, is the very body that has undertaken today to actually roll back rights protection. And what we have seen historically, when they overturn historic precedent, it is about increasing inclusion. It is about expanding the rights of those who have historically been the most vulnerable people in our country and ensuring that they are protected. And what we see here is an about face. So it is a staggering, staggering day.
Yeah, speaking of that about face, we know that Justice Thomas talked about overturning some of those other rights. We're talking about gay rights and contraception, saying the court should reconsider all of its substantive due process precedents. What exactly does that mean?
Well, what it means is that historically the Supreme Court has identified that there are certain rights that, while they may not be explicitly listed in the Constitution, are rights that we deem as a people to be so fundamental that they should be protected. And that if ever there is an instance in which legislatively there is a regulation that infringes on that right, that it is the duty of our federal judiciary to look at that incredibly skeptically, to protect the rights of those who are most vulnerable. And today we don't have that. Instead, what we have is a majority of the court, again, rolling back rights protection for women, which is, as the dissenters said, the true curtailment of women's rights and their status as free and equal citizens. And then we have a concurrence from Justice Thomas that is in many ways the most, quite frankly, straightforward of the opinions in terms of where he sees the court going. Yeah, and he says explicitly and clearly, he believes there is no protection of any real unenumerated fundamental rights in the Constitution. And he thinks now is the time to reconsider those Supreme Court precedents that protect things like same-sex marriage, consensual sex, the right to obtain contraception. And so he has said very clearly, despite the fact that Justice Alito's opinion says we are not considering these other unenumerated fundamental rights, Justice Thomas states it explicitly and clearly. He says, I don't think any of this is really something that should be protected under the notion of liberty encompassed in the Due Process Clause of the 14th Amendment of the Constitution.
Did you find it striking at all that a Supreme Court justice would specifically mention some of the cases to reconsider?
Well, it is noteworthy because he truly calls them out. He calls out Griswold versus Connecticut, which is the Connecticut opinion that strikes down a prohibition against married people being able to obtain contraception in the state of Connecticut, and also criminalizing those who would provide that contraception to married people. He calls out Lawrence versus Texas, which is about consensual sexual relations between adults in their home. And he calls out Obergefell, which is, of course, the famous case that legalizes same-sex marriage. One thing that is rather noteworthy is it is true these opinions are identifying rights that have not been explicitly listed in the Constitution, but we have many rights that the court has identified that are not explicitly listed in the Constitution. One of them, quite frankly, is looking at the concept of marriage. He calls out same-sex marriage. He doesn't call out, for example, Loving versus Virginia, which is a Supreme Court opinion that struck down what we call anti-miscegenation laws, which would ban interracial marriage. So he's very specific in the three opinions that he cites. And I think he is using this as his own clarion call, perhaps to signal where the next battles will be.
Ms. Epperson, before we let you go, we have a minute left, and I want to ask you this question about just how Roe v. Wade was rooted. Justice Ginsburg expressed concern that if Roe versus Wade was actually rooted in the Equal Protection Clause, that we wouldn't see what we're seeing today. Would you agree with that?
Well, I do think that the reality is, what we know practically speaking is that this is an opinion that will have drastically terrible effects for women across the United States. And so it is not something that affects all people equally. It is truly something that disproportionately negatively affects women. And what we know, quite frankly, is also negatively affects particularly women of color and women who are poor. And so certainly if this was an opinion that was rooted only in this kind of sex discrimination, it would be a different lens through which we could view this.
American University constitutional law professor Leah Epperson, thank you so much. We appreciate it.
Oh yeah, great insight there. You know, all over the country, local communities are wondering what this possible change to Roe v. Wade could mean for them. Right now, we should point out abortion is legal in D.C.
But could a Republican Congress change that, even if D.C. voters want it to remain legal? That's the question that the Verified team is looking into. Here's Evan Kozloff.
So let's verify. Does Congress have the power to change D.C. abortion laws? We went to these three experts who say this is a complicated legal question. Generally speaking, Congress can pass federal legislation which would set policy in D.C. It's spelled out in the Home Rule Act of 1973.
Constitutionally, Congress controls all legislative authority within the district. So it's this weird place of having its semi-independent citizens, while also Congress and members from Maine to Florida deciding a lot of what gets done.
But our experts agree this would not be an easy lift. To pass a bill, Congress would need 60 votes in the Senate to overpower a filibuster. Plus, our experts say an act to go as far as to ban abortion would face major legal challenges.
This court would be forced to deal with the discrepancy between what they are saying should be a states' rights issue as opposed to a federal issue, and then suddenly upholding any form of federal legislation.
An easier path for Congress would be to go through budget riders, which has been done before. Since they oversee the D.C. budget, they can restrict the amount of funds that would go to abortions in D.C. So we can verify that generally the answer is yes, Congress can pass laws for the District of Columbia. But whether there's the political will or the legal precedent to ban abortion in D.C. remains a very big question mark. With your Verify, I'm Evan Kozloff.